smell weed. Let's say, and they're an adult. Well, if they see evidence of a crime, they can arrest. But other than that, they have to say, well, have a good day. The Attorney General says I can't do that much. What if it's a minor? Well, interestingly, the governor, the legalizing pot was about making money in the beginning and taxing it and making, more and more money through taxes. But the legislators in Newark and Camden said, we're not going to vote for anything unless there's no penalties for our youths. So, and they had the ability to block it. So the Murphy compromise was, okay, there's not going to be any penalties basically for minors on a first offense. And then they also said, well, maybe it's unfair then if someone's penalized if they have a can of beer. So we're taking away a lot of the penalties on that. So the Attorney General's guideline is online. I'm going to post the Attorney General guidelines on our Local 9 Facebook site. But that's what the current law is. Also, interestingly, if it's an indictable offense, that's a 3rd degree or higher, they can fingerprint. But currently, the current guidelines say no fingerprinting for minors. And lastly, also in the 100+ pages of the bill, the edible pot has to not look like candy. The stuff that they were selling in Las Vegas, it looked like the gummy bears or Twizzlers or stuff like that, and the kids were, the kids were doing it. You got to be labeled pot, and it doesn't prevent the dog from eating it because it's food. Okay, let's go through a couple quick cases because I want to try to get done as fast as possible. Case number 1: do police need to see a car operate to arrest and charge a person with DWI? And the court said no. In State versus Thompson Appellate Division, the fact that they got a call, there's someone sleeping in the car in the parking lot of the Wawa, open. The police had the ability to arrest the person and charge them. That's going up to the Supreme Court. I mean, it was different from a case about 25 years ago where the person was sleeping in the car of a closed bar because he said, listen, I left the bar and I was going to stay here overnight. In this case, the person went into the Wawa, bought something, and then obviously had driven there previously. Can the court order defendant to provide the code for their iPhone? New Jersey Supreme Court said yes. State versus Andrews. I'd say the Miranda only applies to basically confessions by the person, but they can compel blood tests and they can compel someone to turn over the passcode. Interestingly, though, we got to thinking. Let's say if a judge ordered me right now to say, listen, I need you to provide all the passcodes for your computer and your phone. I goes, I don't have a clue what they are. Let's see. My hand knows what they are, and it just kind of goes like this. I'd have to look it up. Case number 3. Please continue to have a legal stop where the license plate cover covers the bottom part of Garden State. No longer. When I was a municipal prosecutor, that used to be like one of our easy nighttime things because where they bought it from Maloof or another, it covered the bottom of Garden State, and but the State versus Rosado Appellate Division said no. But can the police run the plates of a car without any kind of probable cause? The United States Supreme Court in Kansas versus Glover said absolutely, because the license plate is open to the public. They're just running it, just like anyone has a right to write down a license plate and go to the motor vehicles in their state under the right to know laws, OPRA, and find out who it is. So the Supreme Court said running the plate, so having a plate reader, was not unconstitutional. Expungement laws were made much easier. It's done online. That was something that was pushed by the Newark legislators. There used to be many different kinds of license suspensions for a whole bunch of motor vehicle and criminal offenses. and those were taken away. So, for example, there used to be a mandatory loss of license for a drug charge between 6 months and 2 years. That was taken away for the criminal offense. There was also for drugs in a motor vehicle. The statute said a mandatory 2 years loss of license. That's 2 years long. There's no license suspension permitted at all. Driving without insurance used to be a 1 year loss of license, mandatory. Now that's discretionary with the court. So one of the things the municipal prosecutor has is saying, listen, I'm going to give you the deal, no license suspension. However, if you, quote, give me a hard time, I'm going to ask for license suspension. So that's discretionary with the judge and the prosecutor.
Is the amount for the fine discretionary?
I'd say the amount of the fine is discretionary. And I think it's up to like two grand. So, and the interesting thing now, because of COVID, is the prosecutors now have to work much harder because there used to be a line of 50 people waiting for them to come in. And by the time, you know, the people in the back out there waiting for 2 hours, they finally say, listen, just give me something to get out of here. Now someone's sitting like watching TV and they're on their phone, so it makes it more difficult for the prosecutors because then they're looking at a Zoom screen of someone's iPhone. The shore towns used to rack up a whole lot of money on the underage drinking, and the one where someone had the phony ID of their brother or their fraternity brother, and they were going to get served. There used to be a mandatory loss of license. That was taken away last year. This year, they decriminalized the underage. I mentioned the underage drinking. One of the hammers the courts used to have for people to show up is, you know, I remember Judge Hovich. Oh, no show. Okay, notify motor vehicles, suspend their license. Second no show, issue a warrant for the arrest. Now the courts have lost the ability to suspend someone's driver's license for a no show. They've also lost the ability to suspend a driver's license for the failure to pay fines. So, you know, I was talking to one of the municipal prosecutors because, geez, there's no incentive for anyone to come to court or pay. I'd say there's no. I mean, technically, a municipality can get a judgment against someone, but the person's already a deadbeat. I'd say now DREs. I mentioned there's a case State versus Olenowski where there's fact-finding ordered by the Supreme Court. And eventually, the Attorney General is going to have some specific guidelines for how someone can become a DRE and what the standards are. The problem was there was no standards whatsoever, and the defense attorney who originally handled it said, "Let's say the whole procedure was, trust me, that's my opinion." And the special master said that really can't be can't be enough. DWI laws dealing with alcohol were changed the prior year, so if someone has a low reading and they get the machine hooked up to their car, they present that to the court, then they go to motor vehicles with the order, and then they get their, if it's a low reading, they get their license back. If it's a reading of 0.15 or higher, they only lose their license for like 3 or 4 months, and then get the machine hooked up. Well, let's say you're poor and you don't have a car, you're pretty much screwed. So therefore, what I used to tell people is, people, it's not just poor people that don't have cars. People that live in Hoboken, Jersey City, that were going into working in the city, or I'd say, okay, here's what you gotta do. You gotta buy a piece of junk. You don't even gotta even insure it. Then you gotta have one of the companies come in, and you gotta pay to have it installed, and you just leave it in your driveway or your parents' driveway for that period of time. Otherwise, you have no driver's license at all. Ironically, the push for this interlock legislation was from the Mad Mothers, because they were getting contributions from the interlock companies. To say, oh, our studies are, this is what deters drunk driving. And the last case, which some of you retired police will enjoy. You saved a good one towards the end. State versus Adams. Let's see, two guys tried to rob a couple people going into a hotel room because they thought they were easy marks. I'd say, unfortunately for them, one of the guys is an off-duty police officer. So, who opened fires. It reminds me of like the Indiana Jones movie #1, where there's the Arab with the big sword and he's flashing it back and forth, and Indiana Jones goes like this, done. But there was, because of mass and stuff like that, the victims did not get a good view of it. However, there's that new thing called DNA evidence. The guy's like, blood leaking on the ground and other stuff. So they were found guilty on, by the jury, and then they appealed up saying, well, we didn't get good, effective assistance of counsel, etc. And the court said no. You had your trial, but the evidence is the evidence. Let's say, Perry Mason, Effley Bailey, and the other ones could have got you off on this. So that's state versus Adams. So those are the major cases. Thank you, Local 9. My name is Ken Vercammen. Good seeing you again. I'll shut up and sit down now.